But I can
Okay, we're just gonna be another 5 or so minutes until give some more people a chance to attend. About 5 more minutes.
Good afternoon, everyone, and thanks so much for joining us today. I'd like to welcome everyone to today's webinar, LCA form changes and how they could affect employers. Just before we get to the main presentation, I'd like to go over a few housekeeping items. Firstly, this webinar is being recorded, and we will send a link to download the recording after today's live session. Secondly, we also encourage you to ask questions throughout the presentation. To do so, please use the question function that you'll see on the right-hand side of your screen. So for those unfamiliar with Envoy, for nearly 20 years, Envoy has been on a mission to fix the inefficient, frustrating, and sometimes confusing immigration process. We do that by combining expert legal representation with innovative technology to deliver a platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. We're able to secure work authorization in over 150 countries around the globe. We've been growing rapidly at 46% year over year. And we're particularly proud of our NPS score, which for those not familiar is Net Promoter Score, as a measurement of customer satisfaction. And finally, we have over 1,000 customers today. So with that, let me now introduce you to today's speaker, Scott Tuhagen. Scott is a senior associate at Global Immigration Associates and received his law degree at Temple University in 2012. He was also an articles editor for the Temple Political and Civil Rights Law Review and interned for the Nationality Services Center in Philadelphia. Scott has also worked for the Philadelphia Immigration Court, where he drafted decisions and memoranda on various immigration cases and issues. Welcome, Scott.
Thank you.
Excellent. Just moving on to our agenda for this webinar, we'll start with some LCA basics, and then we'll dive into the recent changes and who they impact. We'll also talk through a few hypotheticals, and then finally we'll take some Q&A from the audience. So with that, let me turn things over to Scott.
Thank you, Manu. Good afternoon, everyone, or good morning if you're on the West Coast. First we wanted to cover just kind of a refresher about what labor condition applications are. This is also known as the ETA form 9035 that you might have seen, but a labor condition application, or an LCA, is the form that is submitted to the Department of Labor as part of an H-1B specialty occupation professional worker petition. The form does establish that the employer is paying at least the prevailing wage to the H-1B worker in the specific geographical area where they are intending to work. And the Department of Labor also requires the employer to attest to the fair working conditions of H-1B workers and U.S. workers alike in this LCA. So the LCA that is certified or approved by the Department of Labor is required to be submitted with all H-1B and then H-1B1 and E-3 work visa petitions. And those last two categories are essentially legally distinct, but the substantive requirements are the same as for H-1B, but they're just for citizens of Chile, Singapore, and Australia. You may be thinking or trying to recall where the LCA fits into the H-1B process overall. So as I mentioned, an employer has to file an LCA first and receive an approved LCA from the Department of Labor to include in the H-1B petition. At GIA, we handle this for our clients. A specific note, which is that if an entity has never filed an H-1B petition before or has never filed an LCA before, first they have to register with the Department of Labor, essentially providing the Department of Labor with evidence of their IRS federal employer ID number. So sometimes that does add a few days or a week to the LCA certification process. So if that applies to you, you would want to think ahead to that timeline. But there are four main labor conditions that the LCA does require employers to attest to, and that is the overall wages of the H-1B worker. Their working conditions in terms of the location and the title and other conditions of their employment, the lack of any labor disputes, and that notice of the filing of the LCA was provided to the company's staff within a required period of time before the LCA was filed as well. So now we're going to go over some of the recent changes to the LCA, and there are kind of two big ones that we'll discuss. So this happened in November 2018, where the Department of Labor released a new version of the form ETA 9035 that would require organizations to list the names of third-party end clients that had foreign nationals on site at those end clients who are going to be employed in the U.S. On H-1B, E-3, or H-1B1 visas. So previously, the LCA had not required the disclosure of the legal business name of this, secondary entity, as they're calling it. You can see here on the screen that in Section F, it does require the employer to state whether workers will be placed at another company's location as part of this LCA. And if they are, you can see that they have to provide the legal business name of that other company. So this is the new big change to the LCA form. The other change is that for H-1B dependent companies, we'll talk about what that is in a moment, but if they are employing individuals that have master's degrees, and that is how they are essentially calling themselves exempt from some attestation requirements that we'll go over, they do actually have to disclose the educational background of the foreign national worker and provide evidence of their academic credentials. So this is quite new. Historically, the LCA has never been person-specific in terms of you're not putting a foreign national employee's name anywhere on an LCA. This is a new development where if this situation applies to a specific company, the employer is required to disclose where that individual went to school with a master's degree, and then provide a copy of the diploma, transcript, or other documentation of the completion of their degree. You may be wondering, why did the Department of Labor make these changes? In some supporting documentation that they released for when these changes were being considered, they essentially said that it would increase transparency as to how H-1B petitions are used. So you can think, or you can imagine that the DOL, in their mission to protect the interests of U.S. workers, that they would think it is in their interest to require H-1B employers to disclose the end clients at which their employees are being placed, to perhaps increase accountability or transparency as to how H-1B workers are, where they're being placed, and how those petitions are being used in the U.S. So in terms of cutting through the clutter here and what it means for you as an employer of H-1B workers, who do these changes impact? So in terms of the disclosure of the end client's name on the LCA, this would essentially affect any organization that is placing foreign national employees in H-1B status, H-1B1 status, or E-3 status at an end client. So an example would be, consulting firms, staffing agencies, or other companies that are placing their own employees at another company's location. For the disclosure of the master's degree holders, in terms of who that affects, this would be organizations that are, quote, H-1B dependent, and as you can see on the screen, this essentially means organizations that have a high proportion of H-1B workers relative to their overall U.S. staff headcount. So for smaller businesses, if you have 25 or fewer full-time employees, if at least 8 of them are H-1B workers, you're H-1B dependent as a company. If you have 25 to 50 full-time employees, at least 13 have to be on H-1B to be considered dependent. And if you have 51 or more, then if 15% of the employees or more are H-1B workers, then your company is considered H-1B dependent in that regard.
And just to be clear, Scott, do you have to meet both criteria for these changes to apply, or is it either of those criteria?
So these are independent changes.
Okay.
Yeah. So if you are not H-1B dependent, but you are placing workers at third-party client sites, you still have to disclose the legal business name of the end client. But if you're not H-1B dependent, you don't have to discuss the employee's master's degree information or anything like that.
Great, thank you.
So, perhaps an example would make this helpful to understand. So in this example, we have a company called ABC Partners. They're an IT consulting company that's based in Virginia. Let's say that they have a contract with an insurance company in Pennsylvania called XYZ Corp. Excuse me, to provide XYZ Corp with software engineers that will help the insurance company, develop their own software that helps them process insurance claims. So ABC Partners wants to sponsor an H-1B employee to work at XYZ site. What steps should be taken in order to comply with the new LCA process? You can see here, this is an image of the new LCA form. On the LCA itself, the ABC Partners would have to disclose that there would be this one worker who is at the secondary place of a secondary entity, the client site of XYZ Corp in Pennsylvania, and their name is right there on the LCA. In our second example of the H-1B dependent company, let's say that we have a corporation in San Francisco that has 70 full-time employees, and 15 of them happen to be on H-1B status, which makes them H-1B dependent because they have 51 or more employees, and at least 15% of them are on H-1B. In this example, it would actually be 21%. So if they wanted to file an H-1B transfer petition to add another H-1B worker to their staff, they would have to disclose on the LCA that they are H-1B dependent, and they would have to state whether they are exempt from some attestation requirements around engaging in recruitment for additional H-1B workers if they are considered dependent. So most companies will try to avoid the need to do this recruitment by considering themselves as exempt from those attestations, which involves them either paying at least $60,000 to the beneficiary as their salary, or hiring someone with a master's degree in a field related to the position. So it is this master's degree holder criteria where if the only way that they are exempt from the requirements is by hiring someone with a master's degree, that's when they would need to state where they got their master's degree or higher and provide those educational records that we mentioned earlier, either the diploma, the transcript, or a letter from the registrar. So in terms of what employers should know for the disclosure of the end client in the first change, some employers might say, well, I do have someone that occasionally works from a client location, perhaps on a periodic basis, or we want to have someone be able to work occasionally from a customer location. How would we address this? And so the LCA regulations do provide for this without having to state that someone is actually at a client site location. So in terms of short-term placements, the LCA regulations do allow companies to place H-1B employees at a different work site for up to 30 days, and in some cases 60 days if the employee is still based at their home work site. Additionally, in terms of locations that would not even be considered a work site that would have to be listed on the LCA altogether, would be periods where someone is spending less than 10 consecutive work days for someone who is primarily based at one location and occasionally travels to other locations, or 5 consecutive work days at any one location for a worker that is considered peripatetic is the word, where they move from multiple locations around the country. The kind of a contrast here would be that if someone is moving primarily from on-site work to primarily working at an end client, that is regarded as a material change that requires a new LCA and then an amended H-1B petition. So if we go back to our example of ABC Partners and XYZ Corp, if ABC Partners had was employing a software engineer at their own office in Virginia, and then wanted to move that H-1B worker to the XYZ Corp office in Pennsylvania, that would require a new LCA and an amended petition to be filed with the USCIS.
Okay, great. Thank you, Scott, for walking through that. We'll now turn over to some Q&A. And just to remind webinar participants, you can submit questions using the function that you'll see on the right-hand side of your screen. So just while we receive some more questions, I'll go through the ones that we've received so far. So the first is, what does a consulting firm do if we do not know the third-party organization where the employee will be placed?
So essentially, the USCIS does require the specific entity to be named. Not only for purposes of the LCA now with these new changes, but in the overall H-1B petition that would be submitted, the U.S. Immigration Service will require a specific detail of where the employee will be placed. So if a consulting firm, doesn't necessarily know where someone will be placed, they would need to, essentially work with their own customers to locate a particular project or engagement for that individual to work on, or explore options for employing the individual at the consulting firm's own location.
Got it. Thank you. And then there's a question just clarifying, the next question is just clarifying the 30 days and 60-day rules that you referenced earlier, Scott, where you mentioned that for short-term placements, in some situations, a company can place a H-1B employee at a new work site for up to 30 days, and in some cases, 60 days when the employee is still based at the home work site. Do those restrictions, is that the maximum number of days in a year? Or how should employers think about what those restrictions relate to?
Yeah, that's a good question. So it does apply within a year. So those are the maximum limits for for an annual period. Mm-hmm.
Great. Thank you, Scott, for clarifying. Next question we have here is, do you think these changes will hurt employees who are working at third-party vendors for continuing on the H-1B process or obtaining a H-1B? In other words, will these changes have an adverse impact to their petition submission?
I don't think it will have any particular adverse impact on the employees themselves. Certainly, the petitions where an H-1B worker is placed at a third-party client site historically and even today are some of the most scrutinized H-1B petitions. given that the USCIS often wants to look into the details of whether there is a valid employer-employee relationship between the petitioning company and the worker. The USCIS perspective is, in some of these cases, they want to make sure that it's the petitioner that is actually the employer and not the end client. So I think those have always received a fair amount of scrutiny, and they still do. But I don't think that the addition of this change where the end client is disclosed on the LCA will have any particular negative impact on the employees themselves or make the cases harder to be approved. I think it does go back to what we were discussing earlier, where the chief function of this does seem to be for greater public awareness of how H-1B workers are placed at different company locations, and perhaps even which companies are using those workers at their locations.
Very helpful. Thank you, Scott. The next question that's come up, actually a very interesting topic here, which is, does this change impact the NDA agreement or contract that the employer has with the relevant third party? And if yes, should we now include this into the initial contract?
I think that concerns around NDA agreements and third-party client sites are certainly were discussed quite a bit, but in the immigration community when these changes were proposed. I think it is not yet determined how this specifically impacts this, given that this was essentially a unilateral change by the Department of Labor. There was a delay in the DOL starting to publish the public records that surround these, given that LCAs are a public record, perhaps motivated by some of those disclosure concerns. But the DOL has proceeded to implement this, and I think it would be worth conversations between petitioning companies and their end clients about how this could affect their contractual obligations to each other.
Great, thank you, Scott. And maybe a slightly related question: does this mean we have to tell the government who all of our clients or customers are?
So this is a very valid concern, and one that we've can certainly understand is a sensitive subject. So the answer is, if your H-1B employee is working at your own company's location, then no, you're not required to disclose who your customers or clients are, with the worker working at your own company's location. Even if they were at a third-party client site, you're also not required to disclose all of the customers or clients that you have on the LCA. It would just be the specific entity at which the person is sitting for their H-1B job. But no, definitely want to reassure people on the call that this change to the LCA does not require the disclosure of the company's customers or clients in any extensive or significant fashion.
Right, thank you. And the next question: if the employee consults for multiple end clients or projects vary over time, does that require an amendment to be filed?
Mm-hmm. So it depends on how the initial petition was set up, but usually, an LCA for a worker to work at a third-party client site with a consulting firm may be certified for only one or two locations of the end client. So if they are working to an entirely different end client, that is a material change that would require a new LCA and a new amended filing with the USCIS, and then disclosing that additional customer as well. So if we go back to the example that we were talking about earlier, if ABC Partners has this H-1B worker who is working at XYZ's office in
maybe we can move back to that slide.
Sure.
Just to remind everyone on the webinar.
Yeah, So if ABC Partners had a H-1B worker at the XYZ site in Pennsylvania, and then the XYZ entity was disclosed on that LCA. And let's say that 10 months later, ABC Partners wants to move this worker to another company's site in Delaware or New Jersey. That is a material change that would require a new LCA and a new amended filing with the USCIS. And then in that subsequent LCA, just like they did here, the employer would have to list that other company on the LCA as well.
Got it. And I think a somewhat related question following on from that. Most companies have technical employees that are involved in different projects at different times. If the employee's visa is in process, is it okay for that individual to be involved with a different client?
Can you repeat that last part?
Yeah, so if an employee's visa is currently in process, is it okay for that person to now be moved to a project at a different third-party client site?
So the answer is that they can be moved, but it does require the filing. It does require another H-1B filing and a new LCA in that filing, listing that new client. And certainly, if that is the situation, you would, as the petitioning company, you would want to discuss with your counsel about how to handle the interplay between the pending petition and the desire to sponsor the worker to work at a new client location while the first one is pending.
Well, thank you. And in these situations which involve third-party clients, where should the LCA notice be posted?
That is a subject of much discussion as well. So the notice that is required to be filed generally has to be posted at the physical location where the individual will work. You can imagine in a third-party client situation that in many times the third-party client may not be interested or may be reluctant or not helpful to facilitate the posting of that notice for the worker at that location. So a good alternative is that the notice can also be provided electronically, on an intranet, or even some companies do it on their public-facing internet websites that the public can see to satisfy the notice requirements as provided by the regulation.
Great, thank you. And then just a clarification question from earlier. If you could clarify when the education background needs to be disclosed on the LCA.
Certainly. So for H-1B dependent companies, they are required to make certain attestations about the efforts that they went through to find U.S. workers rather than hiring an additional H-1B worker. But they can be exempt from having to do that if they agree to compensate the H-1B worker $60,000 or more, or if the individual that they want to hire in H-1B has a master's degree or higher. So the changes here are that, if we can just go back a little bit, yes, right there. If the only reason that the employer is saying they are exempt from these attestation requirements is if they are hiring someone with a master's degree, that is where they have to disclose where they went to school and provide the educational records. So if you are an H-1B dependent company, meaning you have that high proportion of H-1B workers to your overall headcount, and you're not necessarily going to pay someone $50,000 as the salary, therefore, the only way you could be exempt from these attestation requirements are hiring someone with a master's degree. That is the situation when you would have to disclose the workers' school that they went to and provide these documents. So I think, for most companies are generally not H-1B dependent, but for those that are, that's when those specific companies would need to pay attention to this if this would apply to them.
Great, thank you, Scott. Another question here. If we have employees on H-1B and we are physically moving our office from the current address to a new address, do we have to file a new LCA for each of them?
So in this situation, it really depends on the nature of the move, unfortunately. It's that typical lawyerly answer of it depends. If it is within the same general area, known as the MSA or Metropolitan Statistical Area, usually assuming everything else is remaining the same about an H-1B worker's employment, let's just say you're moving a mile away, or down the street, then generally a new LCA is not required and a new H-1B petition is not required. The existing LCA would just need to be posted at the new location. If the company is relocating entirely to a new state or outside of the MSA, then that is generally regarded as a material change that would need new LCAs and amended H-1B filings to be sent to the USCIS.
Great, thank you. And then just one final question. What other LCA changes are expected in 2019?
So far, these are the excuse me. These are the only changes we've seen thus far. The Department of Labor has, essentially just implemented this within the past few months, as we saw, and we don't, see any other changes that have been announced on the horizon for the LCA form for H-1B workers specifically.
Okay. Actually, just a couple of follow-up questions here. Scott, the questions you addressed a second ago. So, in the event of a move, does the employer need to repost at the new location in the event of the move if it's within the same MSA?
Yes, they do.
Okay, great, thank you. And in the example you shared there with ABC company, if they post LCAs electronically, is that suffice?
Yes. So, assuming the electronic notice fits all the requirements that are in the LCA regulations, and there are some kind of detailed requirements in there about how the electronic notice works. Assuming that those criteria are complied with, then electronic notice is appropriate.
Great, thank you. And I think that concludes our Q&A session. Thank you very much, Scott. And just before we wrap up, a few announcements. So, let's move to the next section. Great, so we have 2 more webinars in February. Please do join us next Tuesday for a brand new session that's all about applying big data to immigration. And that's followed next Wednesday with a recap of policy changes. So those are 2 webinars coming up next week. To sign up, head to the website that you'll see there, envoyglobal.com/webinars-and-events to register, and you can save a seat for those webinars. And if you haven't already, we'd encourage you to follow us on Facebook, LinkedIn, Twitter. We'll share the latest immigration news and policy updates, as well as resources from our hub, like today's webinar. And that's it from Scott and I. Thank you very much for joining today's webinar. Enjoy the rest of your day.